Okay. I think we have everyone here today. Mr. Levin, if I could ask you to unmute, I will begin by asking you a procedural question. You need to unmute, Mr. Levin. Thank you. You represent the appellant in this case, is that correct? Okay, you are not, there's no sound coming. I was going to ask if you want to reserve 5 minutes for rebuttal. Still no sound coming. I don't know if our technological people need to do it. There is just no sound. Not yet. You're not on. Still not on, counsel.
During the previous discussion, there's a technological discussion of earlier this morning, and attorney suggested getting off the call and trying to get back on to see if you're...
Let's see. How are you doing, Mr. Levin? Any luck on your end? Is there anything we can do to help Mr. Levin out?
No, sir. Unfortunately, Mr. Levine, if you can hear me, you're going to need to leave and come back in.
Mr. Levin, the suggestion is to leave and then return.
Give us a thumbs up if you heard that.
I read his lips. He said, okay. That was the limit of my skill set.
Modern technology.
Mr. Hawthorne, why don't you speak so we know you're working too?
Sure. Am I being heard?
You are, sir. Thank you. Loud and clear. There's Mr. Levin. We have his face and he's back on screen. Now speak, Mr. Levin, as they say. You're still not sounding in. You're clear. The screen is clear, but there is no sound. Our first oral argument went by way of telephone today for the appellant. It seems that that trend is continuing.
Mr. Levin, you'll have to use the number that's on that email that you received to open this up. Please call that number and then we'll hook you in and you'll pull yourself off the camera and use the telephone.
Your Honor, can you hear me now?
Yes, we can.
Okay, thank you.
I feel much like the Apollo project. The eagle has landed.
I hate technology.
Welcome to my world and my position. I'm looking for my plume and my inkwell, and I'm otherwise ready to go.
And everything was fine during the test earlier today.
Yes,
Yeah,
you were cleared. Did you wish to reserve 5 minutes, sir?
I do indeed. Thank you.
Okay. Mr. Hawthorne's microphone we verified was on, so he's good. So we appear to be all ready to proceed on this matter of 5F LLC and Mr. Hawthorne and Kathleen Hawthorne. Mr. Hawthorne is appearing pro se on his own behalf. I assume then, I do not know. Mr. Hawthorne, are you an attorney?
I am.
Okay, are you licensed in Florida?
I am not.
Okay, so I take it you are representing only yourself?
That's correct. My wife is aware of this matter and has chosen not to appear.
Okay, thank you so much, sir. Mr. Levin, you may proceed, counsel.
Thank you very much. My name is David Levin with the iCard Merrill Law Firm, and we're representing the appellant 5F LLC. We're here today, at the very least, to seek an affirmation of this court's decision and 5F versus Dressing. After a very comprehensive review of Florida case law and statutes, this court in Dressing expressly found that, quote, there is a common law qualified riparian right or privilege to construct docks or wharves from the riparian owner's land onto submerged land to the point of navigability, but not beyond the low water line, subject to the superior right to the public.
Can I ask you a question about that? So
Yes, sir.
in 5F versus Dressing, was there an issue? Was it at issue whether it could go below the water line?
Well, it
What
was
was the dock below the water line?
so,
Below water line? Whatever.
Well,
Before we get to the issue of what that means, mean low water line, low water line.
in the
Was it at issue?
in the Dressing case, it was not at issue. And forgive me for saying this, but there was really nothing in the common law that distinguishes rights for riparian owners with respect to the location of the proposed dock in relationship to the low water line.
Yeah, right. So wouldn't that lead to the conclusion that the language in that opinion and others that says to the point of navigability is what's important?
No, because when you look at all the case law, and in particular, the most important case law is the Florida Supreme Court decision in Thiessen. Thiessen clearly indicated that there was no common law right to wharf out or to build a dock, period. And that the only rights that have existed in Florida with respect to a right to construct a dock are statutory rights that were created beginning with the Riparian Act of 1956.
Yeah, but let me talk about Thiessen. Let me talk about Thiessen because Thiessen, they dredged land to build railroad tracks into a channel. Subsequent thereto, after 1917, our Florida Supreme Court expressed consternation and they disagreed with the state selling these type of lands to private entities because these types of problems that we have in front of us would arise. So thereafter, the Williams case, the Hayes case, Belvedere, Shore Village, Brannan, and Dressing have all said a riparian owner has a qualified right, subject to state regulations, to build to the point of navigability. You can't deny that, sir. Now, what you're trying to do is say that Dressing limits their ability when Dressing didn't even apply because that was a pier in Dressing that didn't even extend to navigability, nor did it even cross the low water line.
Okay.
So as far as I'm concerned, the low water line means low tide.
And
So let me ask you a question. Are you telling us that these Floridians that have these docks across the low water line to the point of navigability are going to have to tear them down because they violate law? All these hundreds of thousands of docks.
What I'm saying is that if those docks are on state-owned submerged lands, and if they were built after the repeal of the Butler Act in 1957, they either have to have the authority of the state to put the dock on state-owned submerged lands, or the authority of the private property owner who purchased in good faith and the submerged lands from the state of Florida.
Well, there's not a case in the state of Florida that says a riparian landowner must have the consent of the submerged landowner. There isn't a case, sir.
Right.
And also what you're trying to do is you're trying to argue to us that your private company somehow has acquired the rights of the state of Florida to enforce the environmental, sewer, everything else, to enforce the law that the states are required to, as a sovereign, to enforce. You have now gained those rights.
No,
And
sir.
you can prevent someone from building a dock to the point of asking Mr. Hawthorne to pay your client $100,000 to build his dock. And then you stipulate to a final judgment for slander of title, which means that you admitted that either some or all of those allegations that you made and threats that you made against Mr. Hawthorne were false.
Your Honor,
That's what you do when you stipulate to slander of title.
if I might, Your Honor. we did not acquire anything from the state in terms of rights to regulate the environment, the right to put pollution onto the property. What we acquired from the state of Florida is what the state of Florida has sold for over 100 years to private property owners, and that is the submerged lands that the state of Florida had previously owned. For over 100 years, the state of Florida sold submerged lands for the purposes of development, either by fill or other uses to private property owners.
And your client is not developing Boca Grande anymore. You're telling these people they got to pay you to build a dock. Your company, your 5F is not using this muck, this sand for any economic purpose other than to extort money from landowners to build a dock.
Well,
What else are they doing? Are they mining gold? Are they looking for oil?
Your Honor, they made an investment in private property that many people have the right to do.
Yeah, and they have to follow the law too.
They had, at the time that they purchased the property, or their predecessor purchased the property in 1958, they had the right to fill in that land and use it for developmental purposes. Unfortunately for their purposes, the law changed, the environmental law changed that forbid them filling in the land just as the lot that.
All right, so they lost that right. But let me ask you this: they lost right, and now they're in a position where they are doing what they're doing now. Okay, so usually the ownership of land gives you the right to exclude, but correct me if I'm wrong. Submerged lands owned by the state. The state did not have just a plenary authority to exclude, right?
Yes,
because no, they didn't. They had it subject to a right of the upward landowner to access navigable waters, and they could, that was limited, they could, in the right of the public interest, exclude individuals who would otherwise have the riparian right to access navigable waters. So, and then the case law, it says a private owner doesn't just step into the shoes of the state and become the state and have the right to say, well, on behalf of the public, I'm going to exclude you from the right you otherwise have to access navigable waters. Am I correct that there's case law that says private owner who purchases submerged lands does not just step into the shoes and get to vindicate the right of the public as against the right of an upward landowner to access navigable waters?
First of all, again, in the Hayes case, for example, where the state sold land to Hayes versus Bauman, where the state sold land to a private developer. That private developer had the right and did in fact fill in all of the submerged lands that was deeded to them to the exclusion of any member of the public. That was what the state was doing back in the day in order to develop the state of Florida and acquire resource finances for its treasury. We are not trying to take over the state's regulatory authority. The state still maintains its regulatory authority, but on state lands that the state still owns, they own those lands in its proprietary capacity, and they can do with those lands as they choose, as long as ultimately it's determined to be in the public interest.
What are they doing?
What is the state doing with respect to their submerged land?
5F.
What is 5F doing? 5F is trying to get something out of the investment that they made.
No, exactly. That's an interesting answer, because what Judge Lee was asking you is what they're doing. What you're saying, they're trying to get money from upward landowners trying to access navigable waters, but the upward landowners are not preventing them from doing anything with the submerged lands, right?
Well, first of all, it's important for me to explain as well that we are not in any way affecting the riparian right, common law right of access.
Yes, you are.
No,
yes,
sure.
You are.
Your Honor,
you're extorting money out of them to exercise the right that they have by common law.
They have neither.
You are interfering with their access to the water, sir.
In both the Thiessen case and the U.S. Supreme Court decision in Shively versus Baldwin, it was very well shown that the common law riparian right of access does not include the right to construct structures upon the submerged lands. So they.
Yeah, but the Supreme Court jurisprudence has evolved since then, sir, and it's clear and it's repeated ad nauseum that they have a right to wharf out to the point of navigability. And I've cited all those cases to you. Also, it's interesting, excuse me, I'm talking. It's interesting that Hayes, you bring up Hayes. Hayes was where they blocked the view of the upland landowner, and they were not allowed to do that.
That's not
And
true.
then in 1950, quit interrupting me, could you please? And in 1957, they talked about the right to an unobstructed view. Well, the Supreme Court expanded that after 1957 to include a right to wharf out to the point of navigability. Am I right?
No, sir, you're not right. You're not right. First of all, the issue in the Hayes case, the court did not find that there was an obstruction to the view. It found that while there's a riparian right of view, the facts in that case did not amount to an obstruction of the view.
It said any person acquiring submerged lands from the state must use the land so as not to interfere with the recognized common law riparian right of upland owners concerning an unobstructed view. And that is when the Supreme Court expressed concern about the state doing what they did with your client, causing all kinds of complex problems in the future, like what we have at hand.
There has never been a common law right to build a dock onto submerged lands. It has always been a statutory right, beginning with the Colonial Act of 1641. The Supreme Court in Sibley, as well as in Thiessen, said that there is a distinction between the common law right of access and the statutory right to build a dock. We are seeking to maintain.
All right, wait, look, sir, can I stop, because that, whether or not that's true, in 2014, this district recognized a common law right to wharf out. I'm assuming you're not going to argue with that, to wharf out. That's part of their riparian right. And it is to wharf out to navigable waters. Whatever came before, we are bound by prior precedent. And there is a right in the second district to wharf out to navigable waters. So doesn't the question become what you've focused on, frankly, I think a lot in your briefs, whether that is qualified by in a manner of distance, and whether you can glean from that a second district opinion to say that that right is limited to the low water line. I mean, what can we just, I just want you to know, what do you think of 5F versus dressing?
What I think of 5F versus dressing is that it did recognize to some small extent, a small limited extent, a common law right to wharf out. But the language in that holding is very clear, and it's the same mistake that we believe the trial court made in this case by ignoring language that this court expressly provided following an extremely detailed review of all of the cases and statutes concerning riparian rights. The language in the 5F case says that the riparian owners, that the common law right to construct wharves or piers from the riparian owner's land onto the submerged land to the point of navigability, but not beyond the low water line. What you're suggesting is that the second DCA made a mistake by limiting the extent of the common law right and should not have included the words, but not beyond the low water line. But
well, sir, let me ask you this question. What if the point of navigability is beyond the low water line?
Then that would be a right that up until 1957 was established by statute, not the common law. The question before this court is whether or not there is a common law right to wharf out, to build a dock, which is distinct from the common law right of access. So if you look at the history of riparian rights, which it's all a statutory history, which ended in 1957 when the Butler Act, which was also called the Riparian Act of 1921, when that was repealed, what happened to the riparian right to construct a dock? It was removed from the statute books, and as Thiessen found, it was not included in the common law of England. So my client has a right to exercise the same rights as any private property owner has to exclude, even if it's for profit. And I might add that the state of Florida, the state of Florida, it leases its lands to commercial marinas, to individual.
This isn't a commercial marina. This is a private landowner that you offered, if he paid $100,000, which is more than the cost of his dock. You offered for him to pay $100,000, and you wouldn't sue him for trespass.
Well,
but yet you settled for $93,000.
What we were doing was exercising our rights using comparative values of the going price for submerged lands in a commercial marina as to what the value of privately owned submerged lands are for docking purposes.
So let me ask you a question. If you're requiring an extraction of money to allow him to access the water, who is interfering with the public's right to access? 5F or the state?
Your Honor, we are not restricting his access to the water. We're restricting his ability to put a dock on our privately owned submerged lands.
That you use for nothing but money. You use it for nothing. There's absolutely no economic purpose to you owning this land. You don't dredge it anymore. You don't create fingers. You're not contributing to the economy of the state.
Before Mr. Levin responds, let me say after this, we'll be invading the corpus of your time. I've tried to keep it on because you've been getting a lot of questions that have been extensive, and I'm trying to give you the most amount of time. So after your response on this one, you should know that you're invading the 5 minutes.
Okay. The state's environmental laws have substantially limited the ability to use the property in the way it historically was used and the way it was historically sold from the state to private enterprise. Nevertheless, it still has value, if nothing else, for mitigation purposes, if we ever did a development somewhere else and needed to mitigate that impact. So it's got value, but the value that we're charging for the ability to put a structure on our property is the same type of analysis that the state uses when it charges a private property owner or a commercial owner of a marina to lease state-owned submerged lands, which they do routinely.
Ms. Levin, before we go there, let me ask a very, and hopefully short question. I noticed I prepared for this OA that the 4th District has cited our opinion in 5F favorably. So does that suggest to you that there are now 2 district courts aligned, or was it just a narrow citation, if you're familiar with the case?
I am familiar with the case, and the decision there was not with respect to what the court there determined was there was a common law right of access, and erroneously determined that the common law right of access includes a right to construct a dock. We've taken that case up, requesting review by the Florida Supreme Court, because there is a clear distinction between the Supreme Court's decision in Thiessen, for example, which distinguished between common law right of access and the common law right to build a dock, which the Thiessen court said does not exist, and that the common law right of access does not include the right to build a dock.
Okay, thank you. Did you wish to reserve the balance of your time?
Yes, sir. Thank you.
Thank you. Let me do my management duties here. Okay. Mr. Hawthorne, as you get ready to proceed, should you need some extra time, since I have been favorably disposed to give it to the appellant, I will be favorably disposed to give it to you as well.
Thank you, Your Honor.
I try to do my best to balance it out. You may proceed, sir.
I expect to be brief. May it please the court, we've previously advised that we will not respond to appellant's brief and arguments. In taking this position, we mean no disrespect to the court, and we've done so for the reasons explained in our pleadings. I would, however, like to make the following statement if you'll allow me to do so.
The time is yours, and Ms. Levin's time will be to rebut the statement.
My name is Bruce Hawthorne. I am not here as an advocate. Rather, I'm a co-defendant, appellee, and victim of an attempt by appellant 5F LLC to extort $100,000 from me through willful and fraudulent misrepresentations and omissions. I am also here as a professional, carrying out what I perceive as my duty to help this court take care of the law. I practiced law actively for 40 years.
So let's talk about taking care of the law. So 5F, you have an issue, and the issue is that there was qualifying language in 5F. It said, but not below the low water line. I'm actually not sure what that means. There's a statement quoted in 5F, quoting Ferry Pass, the 1909 case. It says the shore or space between high and low water mark is a part of the bed of navigable waters, the title of which is in the state in trust for the public. The shore or space between high and low water mark is part of the bed of navigable waters. Judge Sleet asked, what if it's not navigable? What if you have to get past it? So my question to you is, what should we do about the language in 5F that seems to limit the riparian right that it seemed to acknowledge to wharf out to navigable waters at what it called as the low water mark? Is there a difference between low water mark and mean low water mark? How are we to interpret that?
Respectfully, Your Honor, I'm very sorry. Our views on these issues are all contained in our post-hearing memorandum, which do deal with all of the issues. However, for the reasons I've mentioned, I will not participate in the process of responding to arguments that 5F has made here. I really do regret
I'm not
that
sure
I
that
need
was
to
the
do this,
argument.
but I have explained my reasons for doing so in our pleadings. May I continue?
Yes.
Thank you. I practiced law actively for 40 years. For 28 years, I was at King & Spalding in Atlanta, retiring as a senior partner to take senior roles at 3 of America's leading companies. I was executive vice president and chief staff officer at Sprint Corporation, and executive vice president, chief legal officer, and general counsel at Electronic Data Services Corporation, both Fortune 100 companies. And in the 5 years prior to my retirement in 2015, I was corporate vice president, chief legal officer, and general counsel for Huntington Ingalls Industries, Inc., the nation's largest military shipbuilder and a prime contractor for the United States government. Today, I carry a full load as a student and a doctoral candidate in the Huff Graduate School and the Warrington College of Business at the University of Florida in Gainesville. I continue to be an active member of the State Bar of Georgia. Much of my work as a corporate leader involved overseeing and managing litigation at both trial and appellate levels in federal and state courts across the United States. As such, it was my job to set the tone for my company's behavior before the tribunals and to personally assure that our behaviors and those of our counsel met the high standards of professionalism and integrity expected of us and all who appear before the courts. I learned this lesson as a young lawyer at King & Spalding, whose office was next to that of Griffin Bell, who had then recently left the Federal Fifth Circuit Court of Appeals and would go on to become Attorney General of the United States.
Mr.
He taught
Hawthorne,
me-
Mr. Hawthorne, I'm sorry, excuse me, sir. But I feel like I'm getting ready to hear some criticism about your opponent, which really doesn't serve the purpose. He's given his client's version of this case and done a good job. You have indicated to us that you don't want to address the merits. I respect you and your history and your experience and your service as an attorney and member of the bar in Georgia. But if you're going to go forward to do what I think you're going to do, I don't know how the panel feels, but if you're going to make personal attacks as to the way Mr. Levine has litigated this case, that's not going to move this ball any forward at all.
I would have to second that. What we're here for, people of Florida have a court system, and we get paid, and you and Mr. Levin gets paid by his client to be here to talk about the merits of this case. This is an appellate court. We deal with legal issues. We have to make a legal decision. We're interpreting case law. We're interpreting, if you have something to say about that, we would really love to hear it.
Your Honor, I have two motions. We have two
Let
motions.
me just say that this case does not turn rise or fall on your credentials or Mr. Levin's credentials. Mr. Levin has put a lot of work into making his
I
argument.
understand that. I understand that. However, I have two motions before the court in this case. I was encouraged and directed to file those motions before the merits panel as part of this process. My statement goes to the specific issues raised in those motions. That is why I'm making my statements. I am not responding to Mr. Levin's brief, as I said. However, our motion to strike,
The purpose
our
of
motion for
today is to
dismissal and other
respond
sanctions is
to
before the
your
court.
argument that's been made by Mr. Levin, and I had hoped as we've gone through your presentation, there will be some at least tangential response. If you have no response to his argument, we will consider the written motions as we customarily do based on the content of the written motion. So if there is no argument, then I guess you would be telling us that you have nothing further to respond in the way of legal argument to guide our decision-making process. And of course, Mr. Levin then would have nothing to respond to, and that would conclude this presentation.
Yes. So, Your Honor, are you saying that it is out of order for me to speak in support of the motions that I have before this tribunal on this matter?
The purpose of this order that was issued for oral argument was to hear the legal issues in the briefing. Customarily, we do not do written motions and have oral presentations as we are not a trial court.
However,
we do them on the face of what appears in the document. And if we need more, we ask for more written submissions.
Your motion to strike was to
have a
strike.
point, Mr. Hawthorne. I do have a point because you did file a motion to strike, which this court converted to a motion to dismiss. Our motion panel deferred the merits of the motion to us.
yes.
And it's my understanding that the gravamen of your motion is this appeal is moot because of the settlement agreement, which appears to be articulated to cover any type of possible disposition this court could hand down in this case, meaning that if we were to affirm, you might have to pay a certain amount for the property. If we were to reverse and enter a final judgment for 5F, you would pay a certain amount. And if we were to reverse and remand for further proceedings, you'd pay a different amount. Is that correct?
Your Honor, yes, we have, our motion raises several reasons of serious concern that should be thought about by this court. In earlier hearings today, the court expressed concerns about giving advisory opinions. And yes, those issues are fully made and briefed in our papers. I have no need to say anything more about that. We have said what we need to say on those subjects. However, we have also brought to the court's attention that the context of this appeal is extremely important, and it raises serious issues involving the integrity of this court and the judicial process. The court can decide not to hear those things, but I have only 2 or 3 more minutes to go, and I will be done. And the statements I will make have been fully developed in our pleadings.
Could just, I'll
Pursuant to
speak for
that.
myself, just avoid, we don't need to hear any more about your credentials or anything more about Mr. Levin.
You are going to present a legal argument on the content of your motions?
My motion suggests that involvement in this appeal runs the risk of involving this court in a pattern of illegal activities, misconduct. That I have explained that fully several times in our materials. Appellant initially responded to that, and then when we when an appellate found that we would be allowed to make our motion in the process of this appeal, and when we called to the court's attention that misconduct can involve misconduct by omission as well as intentional misstatements, appellant chose to stand mute in response to our issues. I do believe with that before this court, it's imperative for the court to hear what I have to say, because it's my duty to bring matters to the court involving the efficacy of the judicial process. It's the duty of the court to take care of the law and make sure that the highest standards are involved and the judicial process is not prejudiced before it or before the court of Florida. So I will do what you would like me to do, but I have a statement to make, and it'll be up to you to let me make it or not.
I tend to favor the use of the court's time to hear members of the public pro se or otherwise as they pertain to the legal issues that are presently before us. The motions we will be hearing, as we would hear anyone's motions following this oral argument, we will consider them as well as the legal issues presented here today. I have no desire to restrict someone's ability to address the court, but we are required to address the issues that are done by briefing, is my understanding, not necessarily done by the motions.
Your Honor, I'm fine with that. The pleadings before the court are what they are, and
Yes, sir.
there was nothing in the notice of oral argument saying that the court wanted to focus its attention on certain things and not the motion. If the motion can be heard at another time.
The motions will be considered today, following this oral argument day that we have. When we go back to deliberate, we take everything that's pending. If there's anything further that we would require, we would send out a written order requiring additional written submissions. The purpose of oral argument, and many of us are in the same common practice, we do oral arguments today on the issues that were raised in the briefing. The issues that were not raised in the briefing generally are not considered unless there's a subsequent order by the panel to include those. That way we're all starting with the same professional understanding, because normally the case law says issues that are not raised in the briefing are deemed waived. Therefore, we can't consider them. So if you are content, and I think the panel may be content, I don't think that Mr. Levin has a rebuttal to arguments that were not made in response to his argument. It would seem to me that we are then concluded, but I will defer to the panel in case, I doubt my own infallibility, so I preferred the panel of three to them to tell me that whether I'm correct or not. And they have no hesitancy, I suspect, to tell me whether they view my presentation here as an appropriate and an appropriate standard for our court, and that I've concluded properly. So,
well, this does not go to whether you're correct or not, Judge Custom, but I do have a suggestion, Mr. Hawthorne, and my colleagues can, chime in. If you have legal argument why we should affirm this case, go for it. Let us know.
All of those arguments are contained in our post-trial memorandum, which are referred to and in our reply and called to the attention of this court. I would direct the court
you
there.
have legal argument. You want to tell us
argument.
why to affirm? Well, if you want to tell us why to affirm, tell us now. Give us your legal arguments why to affirm.
So
We have a decision to make. It doesn't have anything to do with your
Is the
credentials.
court familiar with our pleading? In other words, we have filed with the court our arguments in detail.
Yeah, you filed a motion. You filed a motion to strike, and then you filed.
No. Our reply.
Yeah. Let me finish. You filed a motion to strike. Then you filed a response to the initial brief, incorporating the motion to strike. So tell me your legal arguments for affirming.
Your Honor, we filed a reply, and we incorporated a document entitled Defendant's Post-Trial Memorandum, a 15-page document explaining all of our reasons why.
Do you want to make those arguments now? Do you want to make the arguments of why we should affirm, the legal arguments why we should affirm? This is your time. Go for it.
Your Honor, as I explained, this matter has been resolved. I have no dog in this fight.
Okay.
Okay. And I think we are back where we were a moment ago. I think we are concluding this argument. Mr. Levy, there's nothing for you to respond to, is there?
I simply want to apologize to the court for my impetuousness. As you can tell, I'm very passionate about this subject.
Hey, I don't mind. I think that's what a tourist opponent is supposed to be, passionate and involved on their behalf and on behalf of their client.
But I simply want to assure the court that extortion is not what we are after. We're after a vindication under the law as the Supreme Court in Thiessen has found it. Thank you, Your Honors.
Okay, I thank you all for your patience with us today and your flexibility and your persuasiveness. So we will conclude this matter. We'll allow you to segue out and we'll bring on our next case to resolve. Thank you all.